if you end up with one of these child protective cases against you, if you cooperate fully, do you automatically get your kids back?
Well, cooperate is an interesting word. You know, it's kind of the Bill Clinton, what is, you know. I always tell people, you know, I never want to say do or don't cooperate. It is, again, a very fact-sensitive analysis. There are certain things...
Every case is individual.
Yeah, there are certain things you absolutely should cooperate with. I mean, if the agency comes to your home and they say, we need to see your children, or we're going to come back with a warrant or what have you, you definitely want to let them see your children. It is a requirement for every Child Protective Services worker under the federal legislation that they see the children who are nonverbal and that they actually speak to verbal children to assure that they're okay. If you don't want to give them full-scale access to your home, however, you have a little bit more leeway. But once you get past that steps, it's always best that you stop and say, let me speak to an attorney and I will get back to you within a relatively short period of time. And then beyond that, you know, you really have to look at what they're asking for. The standard for the agency to go into court and seek an order to investigate, to compel you to cooperate with their investigation, is probable cause. So they have to give you some information that would suggest that if you do not comply with whatever they're doing in the course of their investigation, they will not be able to unearth abuse or neglect. So if the allegation is that someone saw you drinking, therefore they want a substance abuse evaluation, well, drinking is legal. You know, if a child wasn't present or harmed or in your care at the time, there was no child abuse and neglect. So how does drinking in and of itself relate to a substance abuse evaluation? It usually doesn't. However, if you have a history, if you're an alcoholic, if you've been in rehab multiple times, if they know that you have been doctor ordered to abstain from alcohol and you're choosing to use, there's a different issue. Perhaps that would be sufficient for probable cause. So it's never as easy as, well, I don't want to, so therefore I'm going to deny you access. The agency can always go to court and apply, and the question that you have to consider is whether or not they're going to do that, and whether or not you want to put your children and your family through that extra step.
Sure. So these cases sound so incredibly layered when you hear about home visits, visitation, court orders, lawyers' visits. How long does it take to resolve a case?
Well, I would love to give, you know, a quick and dirty answer on that. I would say if your case doesn't have any snags, you know, if it's the agency files a complaint, you answer the complaint, ultimately you have a fact-finding hearing and your case is resolved, it's designed to be addressed in about a year. If your child is in foster placement, the statutory time period for a permanency hearing is supposed to be 1 year. And beyond that, if your child is in foster placement for 15 out of 22 consecutive months, the agency is required by law to file for termination of parental rights or another permanency plan such as kinship legal guardianship. So you have that time pressure no matter what. If it's not that kind of case, if your child is not in foster care, but they're in court because they have concerns for ongoing child welfare, they're concerned about your mental health, they're concerned about your substance use. Those sorts of things can drag on and on and on because the concerns may or may not be ameliorated simply by going to have an evaluation. Maybe the evaluation recommends services. Maybe you don't agree with that recommendation and you want to get your own evaluation. So a lot of the twists and turns kind of come as a result of what happens in the case. Then you have to add to it the burdens of the docket in the county where your case is being handled. If your judge has matters scheduled all day, every day, 5 days a week, it is going to be much easier to get into the court system and to address your issues than if your judge is only hearing cases once or twice a week and perhaps even only on a morning or an afternoon. So all of these things kind of weigh into how long it's supposed to take. But generally speaking, I tell people don't ever expect that your case is going to be less than a year unless it is a relatively simple issue. If it is whether or not you used excessive corporal punishment, if your child is not removed from the home, if the court has already reunified you by the time you get to the time of having your trial, if your trial is not going to include experts and it's a he said, she said kind of a situation, those cases resolve relatively quickly, some of those as little as 6 months.
If you find your name on the list, can you get it off?
The list, you mean the child abuse registry?
The list, yes.
Yeah. Well, you know, it's interesting. I've recently had a rash of people coming into my office about this particular issue because their employment can be adversely impacted.
Everything can be searched now, and you don't want to have that sort of black mark against your record.
Yeah, and it's only in those very limited areas that are specific to child welfare. So licensed daycares, licensed residential elder care facilities, jails, group homes, things like that. But, you know, when people are on the list, you have a few ways to get your name off. First, you have a right to file an administrative appeal if you are given written notice that you have been substantiated for child abuse and neglect. Substantiated is the highest form of abuse or neglect finding, and it results in your name automatically being listed on the registry. If you have received that notice, you have 20 days to file an appeal. They will tell you that in writing, and it's a relatively user-friendly process up until the point of the trial, by which time I strongly recommend that you have an attorney. If your case goes to court, if they have removed your child or have they filed some process in court and they're asking that you comply with whatever has been requested, in those circumstances, you're entitled to a trial to vet out the allegations in the complaint. In your trial, the judge is going to make a finding whether or not the agency proved or failed to prove that the child was abused or neglected. If the agency ultimately proves that the child was abused, then the agency has the discretion to determine if that abuse is significant enough to rise to the level of being substantiated, or if it's a lesser offense that we now refer to as established. If your finding is established, you do not have a right to have an administrative hearing, but you can file an appeal in the highest court. And then finally, if your case does not rise to the level of a substantiation, your name doesn't go on the registry, even though the records are kept by the agency. So the registry is a real problem, particularly for people that have older claims. I just recently consulted with somebody who had a finding against her from 1995. And she didn't learn about it.
They don't age out.
They never age out. Once your name goes on that list, it's there into perpetuity. Unlike, oddly enough, Megan's Law. If you're a sex offender, you can apply after 20 years in certain circumstances to have your name removed from the list. Now that list is a public document. The Child Abuse Registry is technically confidential, but it impacts employment.
Sure.
So this woman wanted to be a nurse, and she had actually applied for a position, and they performed a background check and saw that her name was on the registry, and that was the first time that she had heard about it, because back in 1995 they weren't sending out letters to notify people of the fact that their name was on the list. They would simply involve themselves with your family, investigate, tell you, okay, well, we're done investigating, we're closing our case, have a nice day. And the letter that she received made no reference to the registry. And it was only in 2003 that the registry actually, now the law requires that they give notice and an opportunity for an administrative hearing to contest a substantiation and being listed on the registry.
So could she go back with one of those administrative hearings and
Yes.
get it off?
Yes. So now what we find is you can make the request directly of the agency and say, I never got notice of this. Please grant me the right to have an administrative hearing. Sometimes they say yes, sometimes they say no. If they say no, you can appeal their no. And what I always say to people is, it sounds like, you know, it's kind of just, you know, spinning your wheels, and unfortunately it is. So it's a multi-step process. First, you have to appeal the fact that they won't give you a hearing. Then the appeals court, more often than not, we've done several of these, will say, all right, agency, produce the fact that you gave notice, because that's due process, notice and an opportunity to be heard. And if you can't produce the letter and confirmation that the person received it, we're going to require the hearing. And in those circumstances, you're in a better scenario with the agency, because if the claim wouldn't have risen to the level of a violation of the law back when it was made, you can usually negotiate and just have them change the finding without having to go through
It does not come easily or
process.
cheaply.
Not at all.
No,
those cases don't take a whole lot of resources. You know, we've kind of gotten it down to a science at this point as to who to write to and what to say and what to do. But it does take time, and it's not a cheap process.
And it pays to have you in their corner. Allison Williams of the Williams Law Group, you were fantastic. Thank you for all of your insight and your rich knowledge in these often difficult matters. You've been terrific to have on this morning.
Thank you so much for having me, Kirsten. It was a pleasure.